Everyone says Michael Jackson's story ended the moment he settled in 1994. Pay the money, admit the guilt, case closed. That's the myth. Here's the hidden fact. The criminal investigation didn't stop when the check cleared. It kept going for another 8 months, funneled through 2 separate grand juries, and it still couldn't produce a single indictment. If this was an open and shut case, nobody explained that to the 2 grand juries who looked at the same evidence and walked away empty-handed. That gap between what most people assume happened in 1993 and what the paper trail actually shows is what we're breaking down today, not to tell you what to believe, but to show you how a public narrative gets built in real time, brick by brick, out of leaked tapes, tabloid checkbooks, and a news cycle that move faster than the facts could keep up with. This is a forensic look at 5 specific points in the timeline where the story hardened into truth long before the legal system had actually finished asking its questions. Stick around, because error number 5 is about something almost nobody talks about: the literal mechanics of how a 1993 news cycle got built hour by hour, and why that machinery mattered more than any single piece of evidence. Let's start at the beginning. Error 1. The settlement proved guilt. In January of 1994, Michael Jackson agreed to pay just over $23 million to end a civil lawsuit filed by the family of 13-year-old Jordan Chandler. To most people, that number alone feels like a confession. Nobody pays that much money unless they did something. That's the assumption almost every casual retelling of this story leans on. Here's what it leaves out. The agreement itself contained explicit language stating the payment was not an admission of wrongdoing. That's not spin. It's standard boilerplate in nearly every high-value celebrity settlement, and it exists for a specific legal reason we'll get into in a second. More importantly, the Los Angeles County District Attorney's Office stated on the record that the settlement had no bearing on the ongoing criminal case. Detectives went back and re-interviewed Jordan Chandler after the money changed hands, specifically because they were still trying to build a criminal case independent of the civil one. If the settlement had actually closed the book, that follow-up interview never happens. So why settle at all? This is where the technical breakdown matters, because most people have never actually seen how a settlement like this gets structured. A civil settlement and a criminal prosecution are 2 completely separate legal tracks that don't automatically talk to each other. A civil suit only needs a preponderance of the evidence. Essentially, is it more likely than not, while a criminal case needs proof beyond a reasonable doubt, a much higher bar. Jackson's legal team made a calculation that's actually common in high net worth cases. Even a case you're confident you'd win in criminal court can bankrupt you in the civil arena through the cost of the fight alone, the years of frozen touring income, and the reputational damage of a trial dragging on for months in real time. So attorneys structure a settlement with very specific carve-outs. In this case, the agreement reportedly allowed Jordan Chandler to still testify in any future criminal proceeding, meaning Jackson's team did not buy silence from the one person whose testimony mattered most to prosecutors. If this was a payoff to make a witness disappear, that clause defeats the entire purpose. There's a second technical detail worth knowing here because it explains why the number itself was so large. The bulk of the settlement wasn't handed over as a lump sum to the family. It was structured as a trust fund, payable to Jordan Chandler over time, with smaller separate amounts allocated to each parent and a portion carved out for legal fees. Structuring a minor's settlement into a trust rather than a direct payout is standard practice in cases involving a minor plaintiff, precisely because courts want to prevent parents from being able to immediately spend down money meant for a child. That structure doesn't tell us anything about guilt or innocence on its own. But it does mean the $23 million payoff framing, a single number handed to an accuser to disappear, misrepresents the actual mechanics of how the money moved. Now, here's the part that almost never makes it into the retelling. Less than 4 months after the criminal investigation opened, the Chandler family's civil attorney had already filed a $30 million lawsuit. That timeline, investigation, then civil suit, then settlement demand, is the exact sequence attorneys look for when evaluating whether a case is being driven by a desire for restitution or a desire for a payday. None of this proves innocence, but it does mean the settlement equals guilt. Shorthand skips over a settlement's actual legal architecture, and that omission is doing a lot of work in the popular version of the story. Error 2. The physical evidence matched. In August of 1993, investigators executed search warrants on Jackson's properties, including Neverland Ranch, while he was overseas on tour. This is one of the most consequential and least discussed moments in the entire case, because the outcome directly contradicts what a lot of people assume happened. The search turned up no physical or medical evidence supporting the allegations. Investigators also interviewed other children who had spent time around Jackson during that period, and none of them corroborated any pattern of abuse. 4 months later, in December of 1993, prosecutors obtained a warrant for a physical examination of Jackson's body, based on a description Jordan Chandler had reportedly given to investigators. This is the moment that gets referenced constantly in documentaries and think pieces as the evidence that sealed it. But the actual public record on this specific detail is far murkier than the popular narrative suggests, and it's worth walking through exactly why. Here's the technical piece almost nobody explains. A body search like this produces a sealed evidentiary record, not a press release. What actually reached the public came out in fragments, leaked law enforcement sources at the time, and later, competing characterizations from both prosecutors and Jackson's defense team made years apart from each other. Early reporting immediately following the search cited law enforcement sources indicating the description did not match. It was only in a later interview that the lead prosecutor suggested otherwise. That's a meaningful inconsistency in the chain of public statements. An inconsistent chain of custody on a claim this significant is exactly the kind of thing a forensic timeline is supposed to flag. Perhaps most tellingly, when the case went before a grand jury in the spring of 1994, those photographs were reportedly never introduced as evidence. If this had truly been the smoking gun piece of physical evidence, its absence from the grand jury proceeding is a genuinely strange omission. Prosecutors don't typically leave their strongest evidence in a drawer. None of this means the search was faked or the description was fabricated out of thin air. What it means is that the evidence matched became a settled fact in public memory well before the underlying record was ever settled at all. That's the pattern we keep finding throughout this timeline. A claim gets stated once, gets repeated without its caveats, and by the 10th retelling, it's treated as established fact. Error 3. The extortion angle gets ignored. This is probably the least known piece of the entire 1993 case, and it deserves its own deep dive because almost no mainstream retelling spends real time on it. While the abuse investigation was underway, a second parallel investigation was opened into Jordan Chandler's father, Evan Chandler, for extortion. Investigators found that Evan Chandler, despite working as a well-paid dentist, was more than $68,000 behind on his child support payments at the time these allegations surfaced. That detail rarely makes it into casual summaries of the case, but it's a matter of public record from the extortion investigation itself. Here's where the technical breakdown gets genuinely interesting because most people have never had the mechanics of a covert evidence-gathering operation explained to them. Jackson's team, working through a private investigator, arranged for a third party to record phone conversations with Evan Chandler in an attempt to document a shakedown in real time. In one of these recorded calls, Chandler discussed a plan to damage Jackson's reputation and secure a large payout. Investigators call this kind of operation a consensual recording, meaning at least one party to the conversation, in this case the person being recorded by, consented to it being taped. This matters because two-party consent laws vary dramatically by state, and California is one of the strictest two-party consent states in the country. That's precisely why this recording became such a contested piece of evidence. Its legal admissibility and its ethical framing were argued over from multiple angles, and its release to the press, after the tape had already been edited, became its own scandal layered on top of the original one. So what happened to the extortion angle? After a 5-month investigation, the deputy district attorney overseeing it announced no charges would be filed against Evan Chandler. But listen closely to the actual reasoning given, because it's more technical than he did nothing wrong. The DA's office cited a procedural failure. Jackson's own legal team had not filed the extortion complaint within the required time frame. Combined with the fact that California law generally favors settlement negotiations over prosecution when both sides are actively negotiating in good faith. In other words, the case wasn't dismissed because investigators concluded extortion never happened. It was dismissed on a technicality tied to filing deadlines, while the same prosecutor's office simultaneously stated that the negotiations looked more like an attempt to settle a civil dispute than a criminal shakedown. That's a genuinely ambiguous finding, not a clean exoneration in either direction, and treating it as a decisive verdict in either direction misrepresents what the DA's office actually said. It's worth understanding the negotiation sequence itself, because it's stranger than most summaries let on. According to accounts from both sides, Jackson's team made a series of counteroffers specifically designed to be unreasonably low, starting around $1 million against an initial $20 million demand, then later dropping to a fraction of that. Not because they expected those numbers to be accepted, but because investigators wanted the other side's reaction captured on tape as evidence of intent. That's a documented investigative technique, offering a deliberately insulting counter to provoke a response that reveals motive. Whether you read the resulting tapes as proof of a shakedown or as an ordinary, if unusually tense negotiation between attorneys depends heavily on which side's framing you trust. And that ambiguity is exactly why the extortion case never resulted in charges against anyone on either side of the table. Error 4. He never actually faced a trial. This one is simple to correct, but it matters because it shapes how people weigh everything else in the story. In 1993 and 1994, two separate grand juries, one in Santa Barbara County, one in Los Angeles County, reviewed the evidence gathered by investigators. Neither returned an indictment. Prosecutors at the time described their own investigation as frustrated by an inability to find direct evidence supporting the molestation charges. The Santa Barbara grand jury disbanded in the spring of 1994 without acting. The Los Angeles grand jury followed suit shortly after. But the case that actually matters most for this myth happened over a decade later. In 2003, following a British documentary that showed Jackson discussing his practice of sharing his bedroom with children, a new investigation opened, this time involving a different child, Gavin Arvizo. Jackson was arrested in November of 2003 and formally charged in December, facing counts that included lewd acts on a child under 14 and administering an intoxicating substance to a minor. This was not a settlement, and it was not a grand jury review conducted behind closed doors. This was a full criminal trial, held in open court in Santa Maria, California, that ran for roughly 3 months. The judge presiding over that trial made a decision that should have made the outcome easier for prosecutors, not harder. He allowed testimony about the earlier 1993 allegations to be introduced as evidence of a potential pattern of behavior. That's a significant legal advantage for the prosecution. Juries are normally shielded from unrelated prior allegations, specifically because of how prejudicial they can be. And still, on June 13, 2005, the jury returned unanimous not guilty verdicts on all 14 counts. Multiple jurors said afterward that they had expected far more convincing evidence than what the prosecution actually presented in court. This is the piece of the record that gets flattened the most in retellings. People conflate "he was accused" multiple times with "he was convicted," when the only time this went in front of a jury with the power to convict, under a legal framework that let prosecutors use the 1993 case against him, the result was a unanimous acquittal on every single count. Error 5. How the news cycle actually built the narrative. This is the part almost nobody breaks down properly, and it's the real engine behind everything else on this list. Because facts alone don't create a narrative. A narrative gets built through repetition, timing, and financial incentive. And 1993 happened to collide with a specific transitional moment in American media that made this story uniquely vulnerable to distortion. Here's the technical layer. In 1993, the tabloid television and print ecosystem, shows and outlets built entirely around checkbook journalism, was at the peak of its financial power. And it operated on a business model most viewers today have never had explained to them. Outlets like certain tabloid papers and syndicated television news magazines paid sources directly for exclusive access to information, a practice mainstream newsrooms generally avoided, but tabloids treated as standard operating procedure. Once one outlet paid for and published a claim, wire services and local affiliates could then report, "It has been reported that," legally insulating themselves from having to verify the original claim themselves, while still amplifying it to a national audience within hours. This is called source laundering in media criticism, and it's one of the most powerful mechanisms for turning an unverified claim into something that feels independently confirmed, when in reality, it's the same single source being repeated through a dozen different mouths. Layer onto that the specific timing of the 1993 case. The initial leak of the police search happened while Jackson was actively touring internationally, meaning news outlets had wall-to-wall footage of him, arriving at venues, performing, being swarmed by press, to run behind any headline they wanted, whether or not that footage had anything to do with the actual allegations. Television news in the early 90s was also entering sweeps periods multiple times a year, specific weeks when Nielsen ratings determined future ad rates, which created a direct financial incentive for local affiliates to lead with the most sensational version of any ongoing story precisely during those measurement windows. A recorded phone call being leaked to press, then aired, then debated on air, then referenced by competing outlets who hadn't independently verified it. That entire cycle could complete itself within a single 24-hour news day, well before any court, grand jury, or investigator had reached a conclusion. There's also a distribution mechanic worth understanding, because it's the part that actually explains how a single leaked tape reaches 50 million people by dinner time. National wire services function as a kind of central nervous system for local news. A single story filed by one reporter gets picked up, reformatted, and redistributed to hundreds of affiliate newsrooms across the country within hours, each of which adds its own local anchor reading the same underlying wire copy. That system exists to make local news efficient, not to fact-check international celebrity scandals. And in 1993, it meant a single unverified claim from one outlet could appear on evening broadcasts in dozens of media markets simultaneously, each one lending it a small extra layer of perceived legitimacy simply by being repeated somewhere else. Multiply that by the newly emerging tabloid television format, shows built entirely around dramatized reenactments and paid interviews, and you get a feedback loop where the volume of coverage itself became evidence of seriousness in the public's mind, independent of whatever the underlying investigation had actually confirmed. This is why the forensic timeline matters more than any single piece of evidence. By the time the first grand jury even convened, the public had already been through months of leaked tape excerpts, competing statements from unnamed police sources, and tabloid exclusives, all consumed as if they were the same tier of information as an actual court finding. The legal process was still working through its slow, methodical stages. The media process had already reached its verdict and moved on. That mismatch in speed is not a conspiracy in the sense of a single coordinated plot. It's a structural feature of how incentive-driven media operates when a story involves a global celebrity, and it's a mechanism that would look eerily familiar to anyone who has studied other high-profile media firestorms since. A responsible breakdown of this case has to include what the counterargument looks like, because pretending it doesn't exist would be its own kind of narrative engineering. Multiple other individuals, across different decades, have alleged abuse by Jackson, and some of them previously denied any wrongdoing before later reversing their accounts. Wade Robson and James Safechuck both testified as children that nothing improper occurred, then years later as adults alleged the opposite in lawsuits and in the widely discussed 2019 documentary Leaving Neverland, which was met with strong critical acclaim from reviewers who found their accounts detailed and credible. Jason Francia followed a similar arc, telling police in 1993 that he was never touched, before later testifying under oath in 2005 that he had been. And as recently as this year, members of the Cascio family filed a new lawsuit alleging abuse, having told Oprah Winfrey in 2010 that Jackson never touched them inappropriately. That pattern of reversal is genuinely difficult to interpret cleanly in either direction. It can reflect years of psychological processing before survivors feel able to speak, family or financial pressure to recant, or, in the view of skeptics, exactly the kind of pattern you'd expect if a symbol of wealth attracted opportunistic claims once his estate became worth pursuing after his death. The honest answer is that serious people, including journalists, attorneys, and forensic psychologists, disagree about which explanation fits the facts best, and the matter remains legally unresolved. The Robson and Safechuck case is actually scheduled to reach an open jury trial for the first time, decades after the original allegations first surfaced. This is also why the current media landscape around Jackson looks so split. A major 2026 theatrical biopic about his life reportedly had an entire act depicting the 1993 investigation removed before release. Not for creative reasons, but because the studio was legally barred from portraying the Chandler family on screen at all under the terms of that decades-old settlement. Around the same time, a separate documentary series focused entirely on the 2005 trial became available, presenting the courtroom record in far more detail than the biopic ever attempted. Two projects, released within weeks of each other, telling almost incompatible versions of the same man's life, which is itself a pretty clean illustration of everything we just walked through. The legal record and the popular narrative still haven't caught up with each other 3 decades later. So where does that leave us? Not with a clean verdict, because the honest version of this story doesn't have one yet. What it leaves us with is a far more interesting question than guilty or innocent. It's this: how much of what you think you know about any high-profile case actually comes from a courtroom? And how much of it comes from a news cycle that reached its own conclusion long before the evidence did? That gap between legal fact and media consensus is where this entire story actually lives. And once you start looking for it here, you'll start noticing it everywhere else too. Every one of the 5 points we walked through today survives contact with the actual public record. The settlement clause, the raid findings, the extortion investigation, the acquittal, the mechanics of the news cycle itself. None of them, on their own, settle the larger question. What they do is force a harder, more useful question than the one most retellings ask. Not, was he guilty, but how confident should you actually be in a version of events that was built this fast by a system with this many financial incentives to get it wrong? That question doesn't just apply to 1993. It applies to almost every viral story you formed an opinion on in the last 5 years. If this kind of forensic breakdown is useful to you, stick around, because there's a lot more of this timeline left to dig through.